We're ready for argument in 2250.
May it please the court. Mr. Sanders and Mr. Keltner will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Sanders will open the first 15 minutes, and Mr. Keltner will present the rebuttal.
May it please the court. Just last month in Van Dyke versus Navigator, this court said that a fundamental premise is that a text means the same thing today as it did when the parties executed it. In this case, the parties used the word escrow multiple times in crafting an agreement where a non-party was going to hold funds whose title was going to be determined by conditions in the agreement. In open court, Mr. Fisher's attorney designated Holmes, who was the attorney for Raymond and Boozer, as the holder of a brand new, separate account because Fisher's attorney didn't want to pay the taxes, and Holmes agreed. He said, "I'm going to control the account, and I'm going to remain," in his own words, "on the hook." All the parties testified on the record they understood and they agreed to this arrangement.
When an attorney has a fiduciary duty to his or her client, in light of this type of an agreement, how do you reconcile that conflict?
I think the rules do it for us. Okay. If you look at Rule 1.14, what it says is fiduciary duties for an escrow are different than legal representation duties, so there really is no conflict to be reconciled. Now, certainly, an attorney has a duty, and I think it's similar to the duty in Rule 2.02, to look at the relationship, look at the duties that it initially owes to its client, and decide, can I take on this without conflicting? And in this case, Mr. Holmes made that determination. All the parties heard this on the record. They understood and they agreed to that. So there really isn't a conflict here, particularly because Mr. Holmes could hold the funds, have fiduciary duties that ran to both parties to do that, and everybody understood that was going to be the thing. There's no surprise here, and Mr. Fisher's counsel in their briefing makes a big deal about, well, Holmes was a party in litigation, or he was an attorney for party in litigation, so how could he ever be neutral? And the answer is, there's no surprise. Everyone understood that. That was a feature of this agreement. It was either going to be Mr. Fisher's attorney or Mr. Holmes that was going to hold the money. They ultimately elected Mr. Holmes, and the condition of the agreement was they're going to hold the money, and ultimately the judicial determination is going to decide the title. So everyone understood and intended that, so there wasn't ever a conflict from the very beginning.
Even assuming that we agree with you that the parties can entrust their funds to one side's lawyers, and they can even call it escrow even if it's not the ordinary meaning that we usually give to escrow. They can do all of that, but isn't the real question here then who bears the risk of loss when there's some failure of payment because escrow fails or some other condition? And doesn't the settlement agreement condition the release of your client from the agreed judgment based on payment, not on placing funds in escrow?
Well, those are two different things, and they're two different parts of the settlement agreement. So the first part of the settlement agreement was we have a forbearance agreement and an agreed sum, and if you pay the $1.3 million, I believe it was, under the forbearance agreement, then the $1.7 million agreed judgment goes away. That's part A of the settlement. The escrow provision was something different and something separate from that, and that was one, and the reason for that was these were designated accounts that were going to be paid out over the life of this contract, and they couldn't know how much that was going to be because we didn't know, and part of it was...
Right, but ultimately doesn't the agreement say if there is a default in the payment obligations under the forbearance agreement, then the agreed judgment will come to life?
Yes, with regard to the $1.3 million. This is not that. This is a different part of the agreement that's unrelated to that payment. And I don't think there's any dispute here that the $1.3 million was paid, which took care of the agreed judgment. This is a different section, a different payment, a different obligation, and the remedy there, and I think that's why this matters, was the funds held in escrow.
The funds held in escrow were funds that were accelerated payments, right?
Well, they were different.
As they came in instead of at some other, I mean, it looked to me like it was either forbeared upon payment of $20,000 immediately and then some other payments with the remaining over 48 months, but accelerated upon receipt of payments from the Capstone project.
Right, and I think this is a different project with different funds. So they're actually two different things. That was sort of a definite fund amount that was going to be paid. This was a separate project that was going to be put in the
But
escrow.
isn't it all conditioned on payment as opposed to escrowed? That's what I'm trying to figure out, is who bears the risk of loss when, I mean, it could be the same if you did an ordinary escrow arrangement and placed it with a title company, and the title company, failed for some reason, and the funds were lost. Who bears the risk of that loss in this agreement?
Well, if we're talking, to your point about it being conditioned on payment, no, I don't think the agreed judgment was conditioned on the payment of the funds in the escrow. I think those are two separate things. But with regard to who bore the risk of loss for the escrow itself, the answer was whoever ended up winning the ultimate appellate argument. And, in a normal escrow, the title shifts based on the performance of the parties of various conditions. This one was a little bit unique. And the closest case we could find is the Eighth Circuit's decision in In re Newcomb, where you actually had a similar arrangement where there was an escrow that was holding funds pending the outcome of appellate proceedings. And the court there said, really, what everybody holds here is a contingent right. Once one of the parties paid the money into the escrow, they lost the right to get it back. They had a contingent right, and the right was contingent on who wins at the Court of Appeals. That's exactly what we have here. Both parties had a contingent right, and ultimately whoever ended up with it is the one that ended up losing the money when the escrow took it. There was no way for us to get it back. There was no sort of performance that was due from us. All CTMI and its principals had to do under this agreement was pay the funds into the escrow to Mr. Holmes. They did that. That's undisputed. The calculations are not at issue. So they performed by doing that. At that point, they had no further obligations.
Just say if this court's decision in the first case had come out the other way, and meanwhile the money had been stolen, nobody knew about it, the risk of loss would have been...
CTMI is left holding the bag.
And who would have borne the risk of loss if, say, that the money was never, the Devon money, so the big chunk was never paid to the account that Holmes controlled?
I don't think that's a risk of loss so much as that would have meant that CTMI and its principals breached the contract. Certainly they'd have a remedy there.
Against Holmes?
Well, if the question was, did CTMI and its principals actually never deliver the money to the escrow, that would be our failure. So we're the ones who had the obligation to segregate that money out when it came in, pay it over to Mr. Holmes's control, take it out of our control. Had we never done that, we wouldn't have met our obligations under the contract to even create the escrow in the first
How's
place.
that consistent with the representation that Holmes would be on the hook?
Well, he actually had to get the money first. So our obligation was, the money's going to come in based on these accounts. We take 15% off the top. We then hand that over to Mr. Holmes, who's going to control it. He'll be on the hook. So once it went into his hands, it was out of our control. That's what made it the escrow, and that's what actually
That's what seems to be missing from this agreement is something that takes you off the hook. It says he's on the hook, but is it just the use of the word escrow that takes you off the hook? And if so, what Texas cases tell us that that's what escrow means, that the person who's deposited the money is off the hook?
Well, I think what takes us off the hook is partially that, but if you actually look to the provision and the provision that the Court of Appeals relied on, they say, well, this has no meaning because it said that Mr. Fischer will receive the funds and he didn't receive the funds. But the reality is what the provision says is he will receive 15% of the funds being held in escrow.
It says then Fisher will receive payment of the 15% being held in escrow.
Right.
But you're saying that we're to imply a release of any payment obligation.
No, you're not to imply a release of any payment obligation. Mr. Holmes had an obligation to pay it. He took on those duties by the contract, and our position is, under the law as a fiduciary, to pay that money. He had that duty.
And that's great for Mr. Fisher because then he has two people to sue. But the question is what says that CTMI no longer has that obligation?
Well, it's the designation that he's going to be paid the 15% of funds that are held in escrow. By definition of an escrow, we couldn't get it back. So
it is the word escrow that takes you off the hook.
I think that that's right.
Okay.
And the overall structure of it.
What case says that?
Well, I think in general, there's a number of cases that say one of the key hallmarks of an escrow is the ability to not get it back.
And it doesn't really matter what else the agreement says. As long as it uses the word escrow, you're off the hook.
No, I don't think that that's true. I think that there are cases, and in fact, I think the In re Kemp case from the Fifth Circuit, there one of the parties used the word escrow, but the court actually looks to the indicia in the agreement to see, does it have the other things? So, for example, do both parties understand that it's actually an escrow? You know, the fact that one side uses the word escrow casually doesn't make it an escrow, but do both parties understand? Is there mutuality of understanding? Is there an ability by one side or the other to revoke the deposit? Because if so, it's not actually an escrow because you've never passed your control over to a third party to control it. Is there somebody that's named in the agreement as the escrow holder? Or are we just sort of implying after the fact that we really want this to be an escrow? And I think that the cases that the Court of Appeals relied on that said you have to have a neutral escrow, most of those cases were ones where you're looking back after the fact. Nobody said escrow up front, or maybe they did casually, and a party says, well, actually, this was an escrow. It changes the party's legal obligations. And courts in those situations look at it, and they look back and they say, look, we're not going to imply an escrow lightly. Because when we're going to create a fiduciary duty that no one understood they had, at that point, they've probably already breached it when they learn after the fact. So we look for these indicia, and in this case, we believe all those indicia are here. Everyone knew and understood it was an escrow. They used that word. They created that structure. These are lawyers in open court. And we don't have
Is
to
it right that these indicia that you're talking about come from cases that are not from this court? It happens that there are basic principles of law sometimes. Say, oh, let's find the Texas Supreme Court case that says that, and there just isn't one. Is this one of those areas?
Yeah, I think that may be true. There's a couple of cases that are writ refused cases, some older cases that announce those principles, which technically has this court's precedential value to it, but I don't believe there's a great case from this court that just sums it up. I think from 1920 forward, courts have kind of scattershotted them across Texas law, but I don't know that it's ever been collected. In fact, I think the N. Ray Kemp case from the Fifth Circuit may collect it better than just about any other more recent case.
If we agree that the parties can call something escrow when they place it in the hands of one side's lawyer and one side is the named beneficiary of the account, and that isn't traditional escrow. Why should we imply other traditional concepts of escrow, like as some sort of discharge of obligation under the agreement? It seems like you're wanting to borrow principles of escrow for the discharge of any payment obligation, but you would have to acknowledge that a traditional escrow doesn't have as the named beneficiary one of the parties that's placing the money into escrow.
Well, when you say named beneficiary, do you mean name on the account?
Correct, CTMI account, right?
I do disagree with you there. The Foster versus Aquin case, which is a magistrate decision, I believe, out of the Southern District of Texas from 2011, quotes Black's Law Dictionary, and Black's Law Dictionary actually says, generally it's held in the name of the depositor, CTMI, and the name of the escrow holder, Holmes. That's exactly what this was, so there really isn't anything uncommon with that arrangement. And as an attorney, under the rules, you know, the IOTA account's meant to be a very short-term account. Here, all the parties wanted it to be interest-bearing, so really the rules would have required him, and the parties' agreement required him to start a new account, and the way to do that would have it in both names.
So although CTMI's name was on the account, by agreement of the parties, from the bank's perspective, only Holmes had signatory authority?
Correct, and I don't even know that the parties specifically agreed to that term, but
Well, they
factually...
agreed he would manage.
Right.
He would be the sole manager of
Correct, and
control,
factually...
I think was the word.
And factually, that's exactly what happened, and it's undisputed. He had sole signatory authority, he got all the account statements, we had no access, no ability to do anything to affect that account.
So if the arrangement had been exactly like that, the agreement being that, you know, it was in CTMI's name, but only Holmes had any access to it or control over or whatever, but it had been referred to as a trust account instead of an escrow account, would it make any difference to your argument?
Not really, because the same fiduciary duties as a trustee over the money really apply.
So, in response to one of Justice Busby's questions, you sort of conceded, well, yeah, it comes down to the word escrow, but if it had used the word trust account instead of escrow account, you'd be making the same arguments?
Because the trustee ultimately has the duty to preserve the funds, it has fiduciary duties to both parties, and I guess maybe there's a slight difference with escrow. In the trustee situation, it may be that there would be an ability to get the money back if the trustee was holding our money, but that's not this case. So I guess as long as there's no revocability on our end and a third party that has to...
If it wasn't holding it in trust for CTMI, but rather in trust for both parties jointly pursuant to their agreement that only the one who wins in the end is going to get it, then it wouldn't need the word escrow. You'd have the same argument, I guess.
I think probably that's true. I think factually, I think the legal concepts that undergird all of those are the same, though. You've got someone who takes it out of the control of one of the parties and ultimately decides how it's going to be paid based on the conditions the parties agreed to.
But what principle means that, or what would have happened under your theory if the client, instead of Holmes absconding, the client had said, give me back the money, I'm in a cash flow crunch and I need it back?
Well, I think-
How does the lawyer resolve that conflict? He owes a fiduciary duty to
He
both
does. He
sides.
certainly does owe fiduciary duty as an attorney to his client, but under the new escrow duties that he's taken on under this agreement, his answer is, I'm sorry, I can't. I have fiduciary obligations to hold this money for the benefit of both parties and only pay it out under the conditions of this agreement. And that's the end of it. He certainly has his attorney-client duties, but he's taken on separate and different agreements here that he's not allowed to go behind.
I want to be sure I understand your answer to Justice Boyd's question. So is the thing that takes CTMI off the hook not the use of the word escrow, but the fact that Holmes was assuming fiduciary duties to both parties, so that if they structured this as a trust account, instead, your argument would be the same. Because Holmes has undertaken the duty, that lets you off the hook.
I think it's the undertaking of the fiduciary duty coupled with Holmes is taking over control of the money to the exclusion of both parties pending whatever conditions are in the agreement here, the ultimate appeal. So I think it's both of those
Is there any
things.
case that says that if somebody takes on a duty, that supersedes other people who also owe that duty?
I don't know that it says it in that particular sense, but the key feature of the escrows throughout the case law is that it takes it out of the control of the parties into the hands of someone else, who then is going to make sure that the parties' conditions and agreements are carried out solely what they agreed to. So it's the inability of either party to access it, plus the person holding that money, whether you call it an escrow or trustee, I think escrow is probably the correct term, to carry out the conditions of the parties' agreement. It's not just simply they take on fiduciary duties, it's that they take on control, they take on the burden of holding that money, and they're the ones who, the only ones who have the power to ultimately affect a disposition of it based on what the parties have agreed upon.
Any other questions? Thank you, Mr. Sanders.
Thank you.
We'll hear from the respondents.
May it please the court. Mr. Lambert will present argument for the respondents.
May it please the court, Mr. Chief Justice. The fundamental issue in this case, as we've seen, is who bears the risk of loss when funds are deposited with one of the parties' attorneys during the pendency of active adversarial litigation between the parties, and that very money is stolen by the supposed agent or escrow. Mr. Holmes was an attorney for two of the petitioners. He was the attorney during the underlying trial. He was the attorney on appeal. He was the attorney on appeal before this court. He was the attorney for two of the three parties who acted in concert. They filed joint briefs, joint everything, all the way up through and the ending of the case in this court. In fact, up until the point where all of a sudden, apparently, petitioners discovered that the money was no longer there.
That status was no secret.
That is correct. There is
Everyone
no
agreed
secret.
to put the money with the attorney for two of the three petitioners.
No, that was no secret. That was determined right there in the Rule 11 agreement. But as the trial judge said at the time, he said, it's my understanding the parties have agreed to resolve the conflict. We're going to put this on the record. I believe it's important that we get somewhat detailed, so we do not want to invite any future litigation due to a misunderstanding. Well, apparently there's a misunderstanding. It's clear that the term escrow and trust account is used interchangeably a lot. In the disciplinary rules, 3.14, they talk about attorney trust accounts and escrow accounts interchangeably, as if they are the same thing. That does not make an attorney, quote, escrow account an actual escrow. Escrows originally, as we know, were essentially deeds, almost always deeds or similar type things, placed in the hand of an independent third party, and then when this person paid the money over to this person, they would release the deed over and they would have the property.
Do you agree that there were two separate obligations? One obligation to make some payments and then quarterly payments over 48 months, and then a separate additional payment obligation to place 15% of revenues from particular projects, or was the second an acceleration of the first?
Well, Your Honor, there are technically 3 agreements. There is,
Well, the
but
forbearance and then the agreed final judgment.
Yeah,
and then-
there's agreement number 1, which is a $1.7 million judgment with a forbearance that if they paid the around 1.3, that they wouldn't have to pay any more on that part of it. And then there was the future projects, which no money had come in. Nobody knew how much money would ever come in, which also makes for a very interesting situation.
But parties agree those are 2 separate things, the future income stream and the payment of the 1.3 million forbearance.
Yeah, they're related, but they're 2 different parts of the 2 different things. One was for money that was already there. Another was for money that everybody hoped would be coming in, which makes for an interesting escrow if it's an actual escrow, since there was no money in existence to be escrowed at the time of the escrow agreement. That money didn't start coming in until months later, over a period of time, while the case was on appeal before the Dallas Court of Appeals. After the Dallas Court of Appeals ruled, it pended for a long time before this court ruled. That's when Mr. Holmes absconded with the money. In fact, he took his last deposit out about a year before this court's opinion came out.
So you can see why the party seeking to recover the money wants it put with somebody else so that the person they're trying to get it from doesn't run away with it. What in this context was and maybe I should ask the other side this, but what was the reason they had to want to put their money on hold like this?
There were a couple of reasons. Number 1, for accounting purposes, it's much easier. In fact, the attorney specifically talked about the fact that, I don't want to put it, intermingle, commingle trust funds, that belong to other clients. They needed to put this 15% in, and then there was interest accruing on it. And so for accounting purposes, it's a heck of a lot easier to have a separate account that puts all that money in. You can see what the interest is. And then secondly, for tax purposes, because the interest is going to be taxed to somebody. In this case, it was specifically taxed to the account owner. There was only one owner of this account. That was CTMI. This is not a
Do
situation.
you agree that it's that traditional escrow puts the name of the depositor as the account owner and that the depositor collects interest on escrow funds while they're being held?
I don't agree with that, Your Honor. What I do agree with is that in a typical escrow account for money, you could have the depositor and the escrow as the people on the account, the co-owners of the account for purposes of access. But here, Mr. Holmes received the statements, but he received it for benefit of the owner of the account. There was only one owner, that was CTMI. So this was always CTMI's money. It was always petitioner's money. It came from petitioner's clients, paid them for petitioner's services. The money came to petitioners, who then sent the money to the CTMI account, and whereupon it was stolen by two of the petitioner's own attorney.
I thought that the record was that the reason for putting it in this account was that your side didn't trust the people on the other side, and so they wanted it somewhere where they wouldn't have the very kind of access and control you're saying that they had all along, based on the agreement that the parties made.
Oh, I think my client absolutely didn't trust the petitioners in this case, and they wanted it to be somewhat separated apart. But the problem here is, as pointed out earlier, what if CTMI says, hey, we need some of this money for a cash crunch? Well, suddenly you have conflict, you have incredibly conflicting duties. If I am truly, an escrow holder, I'm not supposed to give this money out to somebody else, but I have a client who's saying, I want the money. What do I do?
But a client who has already agreed they're not entitled to the money until there's a judicial determination that they're entitled to the money.
But Mr. Holmes was not a party to that agreement. So it's not his job to come in and, if his client wants him to do something that may or may not cause a breach of an agreement,
so
he still has duties to his client.
I kind of hear you arguing, relying on sort of basic principles of banking law, escrow law, attorney-client relationship, principal-agent law. But you do agree that the parties could alter those basic legal principles by agreement.
To some degree,
Right.
yes, you
And so
can.
Isn't the question here ultimately whether their agreement, I think their agreement was that the funds would be controlled by Holmes, that he personally would be on the hook for those funds, and that he would retain the funds and distribute them only once there's a judicial determination of the rightful owner.
Actually, Your Honor, there's nothing in the agreement that says that Holmes will ever pay the money to someone. All it says is that the funds will be received by the prevailing party ultimately on the issue. This is not really an escrow account. It is a trust protective type account where they can allocate this money so that way everybody knows how much it is. They know what the interest rate is. They know that who's going to be paying the taxes on it, all of that. It's not an escrow account in the traditional sense where merely by paying the money to their attorney, petitioners are suddenly completely off the hook. I have no doubt, of course, Mr. Holmes was on the hook as to the owner of the money and the owner of the account. If he absconds with it and violates his duties on that front. But that doesn't mean that he's on the hook vis-a-vis us. We didn't sue him. He was sued by his own, sued by petitioners. They sued him.
If a home buyer places money in escrow for the purchase of a home, and the title company that's holding the escrow account fails, and the money, like here, was stolen, does the home seller have a breach of contract action against the buyer for failing to close the transaction?
I don't know. They may or may not, but this is not that situation. It's not remotely like that situation because this is not.
Well, I think one side in this case is arguing your only remedy is against in my hypothetical, your only remedy is against the title company. And your argument is the remedy may be against the title company, but it's also against, in my hypothetical, the home purchaser whose funds were stolen.
Okay, if we're talking about funds being stolen as opposed to the passing of the title, which is the traditional escrow situation in its inception, the money, I think that there are remedies against both the person who supposedly it's who has the money and who took possession of the money. If I put $10,000 into an escrow account and then the true escrow person took off somewhere and was never to be seen again, the party on the other side never saw that money. They never had it. It was never in their account. Here, CTMI always had the money. Once it came in, it was their money. They separated out 15%. They put it into another one of their accounts, which was being maintained by an attorney for their side. We never had control over this money. We never had ownership of this money. We never had anything on this money.
It doesn't sound like CTMI had very good control over it either since it was stolen.
Well, apparently they didn't. They may have chosen poorly on their choice of representation.
Well, you say once they put the 15% into this account, CTMI had no control over it. I mean, retained control over it. But what does the record reflect in terms of signatory authority and whether and how CTMI could get those funds?
The only signatory on the account was Mr. Holmes. But that does not mean that there are not methods for example, if Mr. Holmes dies, they're going to find out who the owner of the account is. Oh, that would be CTMI, and they would have access to it. If the owner of the account, the person that's putting the money in, has a dispute with the person who's the signatory on the account, that's something that would be resolved by the bank as to whether they would honor the dictates of the party that put the money in and owned the money on the account, or whether their party representative is actually the person that.
And your argument is that because of the nature of the attorney-client relationship, CTMI had the authority, even if Mr. Holmes didn't die, to require Holmes to give them the money because they had control over the account?
I believe that they could have done that.
Did they not have to waive the relationship's obligations that otherwise would prevail in order to be able to allow their lawyer to be an escrow?
If they want to qualify as a true escrow, Mr. Holmes should have withdrawn from the representation and said, I need to step back. You can have the other attorneys represent you
You
through.
didn't-
And
I don't
now
think-
now I'm neutral and independent.
I don't think you responded to the other side quoted the restatement third of the law governing lawyers, section 44, which says this: the arrangement under which the lawyer receives property of a third person of adverse interest, for example, an escrow arrangement, can imply that the client and third person have agreed that the lawyer is to protect the third person's interests. That doesn't say anything about withdrawal.
Well, Your Honor, one thing to look at is I have yet to see a case where someone was making an escrow with not just an attorney that's technically adverse, usually it's a transactional type matter, but someone in active adversarial litigation.
What else could that
actually fighting.
mean? I mean, that I just read to you.
I think it can mean a lot of things. I think it can mean a lot, in a transactional sense, you have competing interests that are going on. There are technical adversaries, even though they are not fighting. Frankly, they didn't cite to a specific provision in that I could see, but and I didn't actually go through and read the entirety of that. But I did go through the Texas rules that they did specifically cite, and they talk about escrow and trust accounts kind of interchangeably in a sense. But the reality is that this court, over 100 years ago, I mean, 3 times they have talked about what are the elements of an escrow, and they say a deposit with a neutral third party. As early as the 1915 in the Tyler Building and Loan Association case, and in the Puckett versus Hoover case, which I believe we cited from 47, there's the Pickle versus Whitaker case, which was a writ refuse case from 49. Now, and
But
these are,
the question, though, here is whether the parties' agreement turns Holmes into a neutral third party for purposes of the management of this account, and the restatement provision sort of suggests it does. Here's my question. If you had the exact same facts, exact same agreement, created the exact same account with, in the name of CTMI, and CTMI put 15%, was required to put the 15% in it, but the parties agreed that Fischer's lawyer would be the one managing that account with the account in the name of CTMI, how would the analysis differ from your perspective?
that's interesting, because I couldn't imagine Mr. Shamoon opening an account in the name of an adverse
Well,
client.
these parties certainly could agree to do that. I mean, in fact, you all negotiated who was going to manage this account.
I'm not, yes, I'm not sure that parties really can cause someone who is technically an interested party, an actual party. You know, the attorney is considered as if they are the party because they're a full agent for those purposes. An actual party, if you're depositing the funds effectively with them, it simply isn't an escrow. And the case law, the case law that exists, and most of it is old, although there's a case as late as 2020 that talks about it. You can't put the money with, or whatever the thing to be, quote, escrowed, with a party or that party's agent or attorney, because otherwise it's not an escrow. It may be something else, but it's not an escrow.
Don't all those old cases, are they not consistent with the idea that, of course, what you've just said is entirely true when you're looking retrospectively to try to say, well, was this an escrow or not? And without any clear agreement, any clear statement by anyone, well, no, they gave it to the lawyer for the party. That couldn't be an escrow. They gave it to an interested person, not a neutral third party. That was not an escrow. But all of that is for us to be able to look backwards and see that there is this default principle that ensures that we're not going to impose fiduciary duties like that on someone unless it is clear. But here, the point would be, unlike those situations, what I think maybe Justice Boyd was saying, we have something that purports to opt out of that default rule, and we have everybody using that word, even in this court. So it wasn't just a colloquial reference to escrow a few times in a trial court proceeding. It's in brief after brief. This court used that term to describe it. So it was something that if it wasn't an escrow, to continually call it that seems puzzling to me.
Except attorneys oftentimes refer to trust accounts as escrow accounts. They always do. In my experience, it's an interchangeable term. In fact, the disciplinary rules use it interchangeably as if it's the same thing. But they're not. it is not the same as the traditional escrow, which generally exempts, and once I put my thing in the escrow, I have fulfilled my half of the agreement, and so now they have to do theirs, or I get it back, or whatever it may be.
The old cases would say that because someone did that and they were not giving it to a neutral party, that was not an escrow. And that's, if somebody ex post is trying to say, oh, it was an escrow all along, we would look and say, well, no, it was not a neutral third party. It was just something else, a contract, whatever. The difference here is that we have something at least in which the parties seem to really go through with some care and just use that word, even though I agree with you that it frequently can be used in the same way as a trust. But we talk about the person who will be the putative escrow agent being on the hook, all of those things that seem quite different from all the fact patterns in the old cases. That's what I'm trying to figure out here.
Most of the fact patterns in the older cases, they were trying to find out if there really was an escrow agreement or not. I don't believe that's the case in all of them, but it is true that is something that was out there. But here, which is why the trial judge says, we want to be clear so we don't have litigation later over what is going on here. There's nothing in the Rule 11 agreement that says, upon payment of these funds to your attorney, you don't have any further obligation. What it does say is that the agreement is completed when we receive the 15% funds that were supposed to be put into this escrow or trust account. We never received, I'm not saying never, we did not receive those funds, and that's why this litigation arose. They filed a declaratory suit that said, gee, we've done everything we need to do. This is an escrow, a true, pure, pristine escrow, which automatically imputes the idea that we are let go and free. It does not say that in the agreement. It does not put that in, because this is clearly not the traditional escrow agreement. I think if you want things to be just like a traditional escrow going through a neutral third party, you need to be very clear.
But to be clear, I want to make sure I understand, if they had been even clearer than what they were here, is it your position that they could not be, that Texas public policy and contract law, settlement, encouragement, provisions of our law, all that stuff would still say they can't do it, or it's just a matter of it wasn't clear enough? Which one is it?
I think in this type of situation where you have an adversarial situation where they're actually litigating the issue over who owns that particular fund anyway, I think Texas public policy has not, should not, ever allow an active attorney in the case that's fighting over, saying my client should have it, my client should have the money, should ever be allowed to be a, quote, escrow agent for those funds.
So that provision of the restatement that I read, I was just reading from page 22 of the brief, the opening brief from the other side. I take it you're saying that we should repudiate that section of the restatement.
I would say that if the restatement actually implies that it could be in an adversarial context, I think that should be repudiated. But I think it should be repudiated by all courts because of the nature of the attorney-client relationship and the adversarial proceedings.
So if we were to disagree with you about that and just go back to sort of background principles of what do the parties want a contract to do, I mean, this situation is not unique to this context. Normally, under the common law, when title passes, risk of loss passes. And so, is that title was held in the name of CTMI in the account, it sounds like, from the agreement. And so it sounds like your second argument is, even if we don't agree with you that an attorney can never serve in this capacity, the parties weren't specific enough to vary that general common law rule by saying that once the money went into escrow, even though it was still held in the name of CTMI, they had title to it, that wasn't sufficient to shift the risk of loss, even though title remained in CTMI?
Yes, Your Honor, that's exactly correct. That's exactly correct.
Any other questions? Thank you, Mr. Lambert.
Thank you.
Governor, you have 5 minutes.
Thank you, Your Honor. May it please the court. Let me address some of the questions the court has answered. First off, part of these can be found in the answers can be found in a 1969 opinion by Justice Reevely when he was still on this court in City of Fort Worth versus Pippin. The contract in escrow is a three-party contract with the escrow agent owing duties equally to both the parties in the agreement. There can be no doubt about that, and no case says to the contrary. And Pippin is cited for that proposition closely. So that's the first one. Let me take on the second one of the ownership of funds. Justice Busby, you brought that up in dealing with the risk of loss. Here's the issue. In this case, the ownership of the funds that would be done in the 2010 adjustment, and by the way, Justice Bland, it is completely separate from the forbearance agreement, deals with different funds completely. The escrow.
It's just not clear in the parties'
Yes.
colloquy because they talk about one payment being accelerated.
That's right, and you are exactly right that it wasn't as clear when you brought that up. I looked back and I thought, I see the problem, but they're different. Remember though, on the 2010 adjustment, both parties claimed title to these funds under the sales agreement. Now, it was CTMI that was charged with collecting them because they were the successor entity. And there's no doubt the agreement does say that the account will be held in their name. But
That's why they paid taxes on it.
That's exactly right, because Mr. Shamoon, for Mr. Fischer, brought up the tax issue and said, oh my goodness, I don't want to pay taxes on those. And that's the reason it was done.
You say it was done, but it says probably what we'll do is have it be a CTMI account, but have it be controlled by me. Are we hanging our hat on a statement of probably as a confirmed contractual promise?
Yes, I cannot get away from that. That is right. And let me tell you, there's a reason for that. The give and take in this, and look at page 82 through 85, gives you the entire thing. There's a give and take about what they meant if anything wasn't clear. I've never seen anything as clear about what was going to happen. The idea that the other side says, look, there was no really obligation to pay out of the escrow account. That's wrong. It's wrong for three reasons. First off, the very specific page 85, twice, the requirement of payment, is it just payment of funds? Payment of the disputed funds? No. It is payment out of the escrow account, twice. That's where it came from. The Court of Appeals missed that issue completely. Now, the other issue is, where does the risk of loss fall? Good question. But the issue here is fairly clear. We had an obligation, one obligation in the agreement itself, and that was to pay the funds in. Then the court would make the determination, then it would be held by somebody else. And by the way, a false premise on the idea that holding an escrow creates a conflict of duties. It doesn't. Here's why. 114 comment 4 to the rules of professional responsibility in Texas point out that an escrow can be taken on, and it's not in the attorney-client relationship. It gives rise to additional duty. You were citing, Justice Young, the restatement third of the law governing lawyers. It's very clear. The obligation you have is not, as an escrow, is not an attorney-client obligation. It is separate. In fact, the rule, one of the rules goes to say is, if you would otherwise be liable, even if you weren't a lawyer. That is precisely what we have here.
Clients would have to agree to that.
Clients would have to agree.
And they did.
And they did so specifically here.
I want to make sure I understand CTMI's motivation for putting the money on ice. You said it was tax related.
No, that was the other side's deals. Our motivation for doing it is they insisted on it as a part of the settlement to let the declaratory judgment go further. By the way, in the 2016 opinion by Justice Boyd on the issue of whether it was an agreement to agree or sufficiently specific, quotes, and what happened there is Fischer argued, look, you don't have to get into implying what the terms are in determining what reasonable funds are, because all you got to do is determine it was sufficiently specific to be enforced.
said it was to
because
let
of the escrow agreement.
Sorry, you said it was to let the declaratory judgment go forward. Was there something more concrete than that CTMI was getting within the context of the litigation, or?
It was resolving the other part of the case, which was the larger part, the payment of 1.7 million, or 1.3 million in exchange for 1.7. It was a trade-off. The idea of it being held separately, if you'll look at the agreement, it starts off with Mr. Shamoon representing Mr. Fischer, suggesting that one of the two parties would hold it. One last thing. It was not a trust account. It wasn't an IOLTA account. After all, IOLTA accounts can't bear interest. That gets swept for the IOLTA program. This was a separate interest-bearing account, like ethically lawyers should set up in these types of situations. So it was a very specific account. By the way, it has every element of escrow in it. Every element. And by the way, Texas courts have not universally held that a lawyer in an adversarial proceeding can't serve as an escrow. There are a number of cases that go the other way and says that's possible. That's Comunidad Balboa, Newington versus Forrester, and Johnson versus Freitag, even specifically suggesting those.
Well, that case, you used it quite a lot, but I took it to only say it was not deciding otherwise. It said,
Yes.
we don't say necessarily that this, but it didn't say the opposite either, did it?
That's exactly right. It says we're not saying it can never be done, but this is a perfect case for indicating if it can never be done, it certainly couldn't. It certainly could be done in this case.
But neither did they say that it could ever be done. They're just saying we're not saying that it could never be done.
That's
strikes me as
precisely right.
non-holding rather than a holding.
That's right, John.
Okay.
Any other questions? Thank you, Mr. Keltner.
Thank you.
Case is submitted, and that completes the argument set for this morning. The marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.